Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican for each service.
Is that correct?
Oh, for Trump's sake. I didn't ask you to interrupt me.
Good morning, good morning. Good morning, test 1, 2. Welcome. Welcome to the Court of Public Opinion. I am the Recovery Addict. It's great to have you all here today. I just did my hair. I can't put my headphones on right, or else it will smush my hair for the whole day. It's got to have this shape for a little bit. Oh, what a morning, what a morning. Eeyore, I see you squeezing to the very back. I see you there. Welcome. Greeners, I also see you first in chat. There you are, Greeners. I saw Eeyore as well. There's Eeyore. Greeners first in chat today. Congratulations, my friends. You being first in chat has its privileges, but it also has its punishment, and we're going to focus on the punishment for you today. We're going to send it to internet ownership for the entire day, at least until we go live again, which we know we have 2 court cases today, so it's only, at worst, it's a half day. It's a half day of work for you, so it's going to be like double what you're used to, but it should be pretty easy. The rest of us do it all the time, Greeners. You'll be fine. All right, welcome one and all. It is fabulous to be here today. I have to tell you, the day started off absolutely wild because
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. One and a half thumbs. Welcome to Wednesday. Yes, everyone except for Michael Proctor is happy about today. He lost his job. That was news this morning. He has been let go. It is an appealable decision, actually. So that broke probably about 15 minutes ago, 20 minutes ago now, maybe. But it's a decision for breach of department policies or something like that was the official term. But he can appeal. He can appeal, and he probably will. All right, we have a few birthdays now that I've completely destroyed my voice, and you got to keep that closed because there's music in the background. Okay. Now that I've destroyed my voice, it's time to celebrate birthdays, and we're gonna try to sing to Katie Russin.
Happy birthday! You look good.
Yes, you do. Deb Pickett, Mel Poy, and Nadine all celebrating the birthday today. Will he testify? I bet he still will. I bet he will. So, everyone, take a deep breath. Stand up, shoulders back. Project your voice to the back of the room. Blend your voice with your neighbors. Warm up with me, if you will. La 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 la. There we go. All right, we're going to sing happy birthday to these wonderful people who are celebrating their birthday today. Happy birthday to you. Happy birthday to you. Happy birthday to Katie Russin, Deb Pickett, and Mel Poy and Nadine. Happy birthday to you. I threw an extra and in there. Almost didn't make it. Katie Russin, Deb Pickett, Mel Poy, and Nadine, happy birthday. I realize there are a million places you could have been, a million people you could have been with. You've chosen to be here with us. The privilege, the pleasure, the honor is all ours. Hopefully we can return some of that joy to you and make your day a little more special. Or help yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Andy's Grill, Tammy Dunlap's house, and Bob Evans. And we're going to add Chris. Here we go. Happy birthday to you. One more time, everybody. Happy birthday to you. Happy birthday to Rick Gruber's nephew, Chris. Happy birthday to you. There you go, Chris. You also get the free pancakes. You also get free pancakes. So help yourself to those. They're wonderful. No better way to start the day than being sung to and to eat pancakes, which is basically cake for breakfast. We just cook it different. Well, it's actually completely different, but consider it having cake for breakfast. All right. We're getting to the good part, which is the drum solo, where everyone gets to help finish off the song in style. If you've never played the drums before, today is your day to master it. So everyone grab your air drum set sticks like this. You grab those. You have to sit down at an air drum set, which is just anywhere in front of you. And you hold the drumsticks and you hit the drums to finish off the song in a big way like this. See, like that? So now that you all know how to do it, please join with me. Todd in recovery, 84 days. That is awesome. That deserves a drum solo on its own. Here we go. Beautiful. Absolutely fantastic. Y'all are official drummers. You can add that to your resume as well. Let me tell you how the day started. First of all,
thank you, sir. You're my new best friend.
You're welcome. First of all, I fixed my bike. When I moved to North Carolina, I brought my mountain bike with me. It is a mountain bike. It is a 21 speed, I think it is. 21 speed mountain bike, which is really helpful for going up and down hills. I live 60 feet above sea level, and there is not a single 1 foot hill between me and the ocean. It is as flat as it can be, but I have a mountain bike. And when I moved here, I put the mountain bike in the shed because I was busy unpacking. And 6 years later, this week, I brought it out of the shed. Not the shed, the one I've never been in, but it actually was down in our basement. And so I got my bike out, and it needed new tires, so I ordered new tires, replaced the tires, forgot to buy the proper valve stem so I could pump it up, ordered that, got those. It was a long process, but last night, bike tires fully inflated, well, most of the way inflated. The bike fully assembled, got out the WD-40 and sprayed everything with moving parts, including the brakes. I didn't think that one through. It's disc brakes. Probably should not lubricate those, but they don't squeak anymore, which is good. And so we went out and did a little test ride. And all the younger kids, including those who were like half my height, tried to ride this bike. This bike is oversized, like 29-inch tires, just massive. And it's tall for me. I'm 6'2", and my young little kid rode it as well. And they all rode it, and they had a blast. And then I get on, and they're like, "Dad, be careful! You could fall. Dad, don't. Dad, we're worried." You know, it's like, do I look that funny on a bike? It's my bike. Anyway, I went for a little ride this morning before the live stream, and I have forgotten how small and uncomfortable that seat is. I kid you not. I didn't realize how pencil thin the seat was, how, I guess, aerodynamic it is, and how little padding there is on it. Wow. So between the legs burning from pedaling and also holding myself up because I can't sit on the seat because that hurts too bad too, it was a great workout when we got one under our belt. So... Now I'm looking at bike seats that more closely resemble the full cushion from a Lazy Boy. And do we get a spandex view? And thankfully, no. It would cause an eclipse, Greeners. It would cause an eclipse. Wait until tomorrow. So sure, life soreness was at it. I can't wait. This is something I need to do. So I'm in for it. You guys keep me accountable. They're actually called saddles in the biking world. There's no horse that would fit under this saddle. I mean, not even a miniature baby Shetland pony. There's nothing that gets it. It's like sitting on the small end of a baseball bat with a doily on it for cushioning. That's what it feels like. So, you guys can probably relate if you've ever done that. But all right, we are a little bit early for court, so I probably overshared today. Just a little bit. It has shock absorbers, thankfully. So the bumps, it's considered a hardtail. So the back end doesn't have shock absorbers. That you're supposed to use your legs and sort of like hop up off the seat. And the front has the cushion. So when you feel a bump on the front, that's when you're supposed to stand up so you don't feel it on the back too. Right, better early than late. Yes, we're here. We are early. We've got a little bit of time. We have nearly 45 minutes before we expect anything to happen from court, and we have 2 court cases today. Overshared. Yes, tiny bit. Welcome. And by the way, we got a brand new member who I forgot to mention. Maureen, welcome to the gallery. Thank you so much. I love, it looks like a parakeet. Is that a parakeet in your picture? A budgie? I don't know my birds very well. My kids probably know. They were holding parakeets yesterday. They went through a little bird sanctuary aviary field trip thing, and it was great. All right, Allison says, what happened yesterday? Catch me up. Oh, my goodness. In the snowplow trial, which is the first one we're watching, defense has done their best to introduce doubt, especially through the detective, they wanted to get in the entire police interview, but the state only introduced parts of the interview through a transcript. They didn't play the video. The reason the state's not playing the entire video is because a couple times, at least during that interview, the defendant talked about previous times where the victim had threatened him. Now, whether or not those happened, we don't know, but he talked about them to police. He also talked about a lot of other things that didn't happen. But they were trying to get that in, and they argued in front of the judge, and it was pretty much an ongoing debate throughout the day as the state is introducing evidence and the defense is trying to see if that opened the door so they can get this other piece in, and they never were able to. The closest they were able to do is play the body cam video from the time he was taken into custody for questioning until he basically sat down in the interview room and the interview began. That's all they got was body cam footage. And it does show that he was tired, that he was, he says he'd been up for 40 hours. He was hungry. He was tired. He was, a little out of it, which is good for defense because you're saying, hey, look, you questioned my guy when he couldn't think straight. And he even told you, he's like, I'm not sure if I got all the facts right. So they've got an out there if he tells his story where he can say, look, I can barely even remember that day. I was just delirious with exhaustion, and I can't. And that would be a story that a jury might possibly believe, other than the fact that he got a lot of details very, very right. So it's a chance. It's better than nothing for the defense, but I don't see how it will help him unless he gets up and testifies. So I think he's going to have to testify in his own defense. That could happen today because that was the last witness for the state. If they're done with him, which I think they are, the state's going to rest. Defense takes over 1, 2 witnesses. I don't know. Are they going to call his daughter? She's already been up on the stand. So, not sure. Anyway, we could be in verdict watch in that trial here shortly. Then we picked up another trial. The second trial is in North Dakota, and this is a cold case trial where I'm going way back here because it's was it 2007 that it happened? Let me try to see here. I think it was 2007. Not that one. Not that one. It's the Nicole Rice trial. There's the judge. She's accused of murdering Anita Knutson, who was her roommate. This was, she was 18 years old at Minot State University. She was found stabbed to death, I think 2 stabs to the chest. She was found in her apartment. Her family is actually the one who found her. Her dad found her. Both mom and dad took the stand yesterday and testified, and it's heartbreaking. They're literally in their golden years, right? And so, of course, they've got, some of the things that go along with that, the hearing loss and a little bit of memory loss as well, and watching them have to relive this nearly 20 years after they lost their daughter, trying to seek justice. Now it's coming to court. And it was hard to watch that. The dad had to testify through an interpreter who was listening for him and typing everything up on the screen. So he was basically testifying through closed caption, though he could speak just fine and we could understand him. So there was a lot. There was a lot there. He found her. he went up, they called, she wasn't answering. They went up. He basically told the management, I need you to let me in. I can't find my daughter. She's not answering her phone. Her car's here. She should be here. And they said, we can't do that. I'll get in trouble if I let you in. He said, you're going to get in trouble if you don't. And so they walked over and they ended up looking through the apartment window where the maintenance man said the screen and a curtain rod or something had been out on the lawn next to the house, and he had thrown them back in the bedroom window. Well, they look in the bedroom window, and there she is dead on the bed. So, of course, they go in and find that that's exactly what that existed, and they call the police. So defense in that case is saying, look at all these other third-party culprits that could be out there. Look at all these people who could have done this. You've got the maintenance guy who should have, he was literally shoving stuff in the window, and there's a dead body right there. We can all see. He should have seen that, and is he possibly involved? Is the sort of the next logical step? They're trying to make the jury think in that one. They've got a prom date who may have been looking for more than just friends. That was rebuffed at some point, and they've got this other kid who may have been troubled for a couple of reasons. That was found with what they say is the murder weapon, and seen running from an apartment with blood on his shirt, and was found breaking into other people's apartments. There are three plausible, and there are three people that would at least qualify as the police would say would look at them as a suspect, or at least a person of interest in the case. And so we're going to find out that some of those people were excluded and ruled out as the evidence comes in. But defense wants to raise as much doubt as possible, and that's what they're doing right now. So a lot of suspicion, a lot of crazy stuff. I will say in the North Dakota trial, we have great camera angles, 1 million of them. It's a crazy court. It has like two big pillars, big square pillars in court. One of them right between the witness stand and the defense table. So that you say you're supposed to be able to face your accuser in court. The witness, the defendant can't see the witness stand because of the layout of the courtroom, which is wild. It has hit and miss audio. Some is fabulous. The defense attorney, either his mic is bad or he doesn't know how to use it. So we're working through that. But great camera angles and good audio for the judge as well. So that's good. They've got wireless mics, but they're not working very well. So I could recommend some upgrades for them. The Sennheiser one I use is fantastic, and it works out to about 900 feet, so you'd be fine with that. But hey, I got some mail. This is something you can shred and throw away. They want us to borrow money from them. What's the other thing? Oh, this is a bill. You can shred that too. No, just kidding. That's for him. All right. Let's see. Delina Foster says, happy dance. I didn't have to confess to being late when I took my seat. I didn't oversleep and caught the hump day yell. 1.5 thumbs up. Yep. Josh sent us a video we can watch. That's 10 minutes and 19 seconds. Let me open that up. That would be a good one this morning because we've got some time. Oh, hang on. Have you ever had like a project that's coming up that's big and huge, and you've done a lot of planning, a lot of preparation for, and then like 2 days before they move the goalposts? My weekend's going to be really exciting. I just got that text. It just got really exciting. All right. The gig's going to be a blast. Where were we? Josh. All right. We have about half an hour, so we have plenty of time to watch this and still catch the opening of court. Yes, we have seen in chat a couple of people, by the way, are mentioning. Hey, hang on. I'm squirrel moment. Dylan Foster, congratulations on 10 months. Thank you very much. It wouldn't be the same without you here. Thanks for your anniversary message there. We have been seeing in chat that we did see that Michael Proctor from the Karen Reed trial fame has been let go from his post for, I think, something about breaching department policy or something like that. So it's vague. I haven't heard the details. Lisa, if tornado sirens are going off, obey them. Be careful. We've got major crazy weather, especially in the central United States right now. There are some parts of the country who are probably out of power right now and aren't hearing this because of lightning storms and everything. Imagine if it was your job. This is just something that you can imagine. If it was your job to film, let's say, an interview that's happening in an auditorium. You're just going to set up a camera in the back and film it. And you got some famous people coming, and you're going to be like, oh, I'll film them. And then you find out that the famous people have a lot of special requests, which you have to comply with, of what equipment they want you to bring. And then you find out at the last minute that you're going to loop in all sorts of professionals from everywhere else, and they're going to depend on you for the feed and everything else. It's sort of like that. So it just got crazy. It's no sweat. We can make it happen. We are professionals. So now I just have to tie in a whole bunch of big corporate companies that are using stuff that I didn't think we were going to get to play with. Josh, I'm sorry. Squirrel moment. My head's in two places. Okay. The word about Proctor, by the way, came from WBX, a reporter for WBX. Let's see. Christina Rex, who's WBZ reporter out of Boston. There's a couple others that are reporting it as well now, but I know it's not come out on the official channel yet. So, missed a milestone from Chrissy G, and you have super. Okay, hang on, Josh. I still can't find your text. Oh, there it is. I see it. It just uploaded. Okay. I've never been to this court before. Okay, we'll try this. You can go with me. How do you say this? Newaygo County?
Have them send someone with more experience.
Newaygo County, 27th Circuit Court. Found it. Okay, and this one is 1019. Trying to find the right one.
It's not your turn to talk. I'll tell you when you can talk.
On February 4th of this year.
That's not him yet. Hang on. I'm looking for it, Josh. It's just not showing up on my feed yet. 1 day ago. It happened yesterday. He's got a zillion different clips. Okay, found it, I think. Well, no, that's not it either. Looking for somebody in blue. Ah, found it. There it is. It was buried. All right. Let's go here.
13129. So, Mr. McQuaig, we called you into court to talk about.
I understand why I'm here, sir. Thank you.
Okay, to get some of these financial assessments paid.
Well, I'm not going to pay anything because nobody wants us to show me where I did what I was accused of. And you can do whatever you want, sue me, do whatever, garnish you, whatever, I don't care. I'm on no stability, you ain't gonna touch that, and if you do, oh well. unless this thing gets watched, and you people can show me on that video where I rushed and grabbed your officer and started this whole mess, you can go kick stones.
Well,
Can we get your
we're
name?
not here to relitigate the case.
Well, then just do whatever you gotta do. Tell me I'm a butthead, throw me out of here then.
So you indicated that you're on disability.
I am,
Okay, how much is your disability amount?
like less than 600.
Okay. Do you have other expenses that you're responsible
Well, of
for?
course, I got a house payment, I got all kinds of expenses. Way more than my income.
Okay. Let's talk about what's your share of the house payment, sir.
I don't know, it's 500, I pay at least half that, I gotta pay car insurance. I got
Hang on.
pay all kinds of stuff, like gas bills, light bills, you know?
Okay.
You know, people think don't give that to you for free.
All right, sir, I'm just trying to get.
I don't even get a food card, so I gotta buy that too. But you know, you guys don't care. Nobody cares, and I don't care. So you know what? Just get me out of here. You ain't gonna get nothing out of me by asking me for information. You already given me about the information I'm gonna get out of you. You won't listen to this. Why should I be nice about this? If you guys can't show me where his officers lied on their police report and got me through all this, then I don't care what you people think. You can kick stone for all I care. You guys are telling me to kick stones when it comes to Washington, y'all can kick stone.
I'm sorry.
Mr. McClegg, I'm trying to be fair with you.
I'm being fair. It ain't fair for me to just get stuck with this and have this the whole freaking time. I'm in here 2 years and not have none of you people watch it. That's unfair. This whole freaking trial was unfair. Thank God I actually got a decent lawyer that persuaded that idiot prosecutor.
So, are you willing to share any other additional information?
No, I'm not.
About your monthly expenses, sir?
Yeah, I got some. You want to give me my monthly expenses? You know more about my bills than I do. I don't even see my money.
I don't hear well. I need to speak. I need earphones.
She's the one who takes care of my finances. I don't even see my money. It just goes into the bank and that's it.
Okay.
If I want money, I gotta go earn it somehow. Really embarrassing thing, but oh well. Picking up cans, you know, stuff like that.
I would say he came in with a chip on his shoulder. Tough situation. It sounds like he's been found guilty, and he's got a fine of some sort that he needs to pay.
That's the way they go on?
We call your officer for help. She called him because the neighbors yelling at her and screaming at her. They don't help. My brother that's standing over there or sitting over there, he gets almost run over by a motorcycle and run off the road. You cops don't help. Why would I pay these piece of garbage cops?
Ma'am, what's your name? What's your name?
Nancy Gill.
All right, Ms. Gill. I'm just trying to assess whether.
I can't hear you, sir.
You can come closer if you want. So I'm just trying to assess whether Mr. McQuaig has the ability to pay
he doesn't.
these financial assessments.
No, he doesn't.
Okay, but I need information to back up your conclusion. Okay.
Tell them that mom's all the bills I pay.
Stop. I'm talking to her. You asked me to talk to her, so I'm talking to her. All right. He indicated that his disability is about $600 a month. Is that right?
Mm-hmm.
That's a yes? Have to say yes or no?
Yes.
Okay. He indicates that he pays about half the house payment, which is about $250 a month. Is that about right?
Yeah.
Okay. Do you know roughly what his car insurance is per month?
$231.
Okay. Other like gas, utilities, phone, that sort of stuff. Can you give me any specifics on those?
Our phone bill, the phone bill runs about close to $400. It's $394.
Okay. Do you or other people
$3.94 for a
pay
phone
a
bill?
portion of that too?
I do, I pay as much as I can, but the mortgage payment is over $500, and I only get $1,500 to pay it, and the LP gas, if I was to run an LP gas, they're gonna set me up on a payment for $105 a month, but that's not what it's been in the past. I've had to pay it all at one lump sum, and I didn't have it.
Okay. Are there other people that live in the house that contribute towards the household expenses? So it's just you and Mr. McQuaig? So the total amount of money that you have coming into your house is roughly $2,100 a month?
And I have to buy wood because I burn wood, and the electric bill, because our stove has been broke, so we've had to run an electric bill, and my rec bill was $500 last month because we had to run some electric heaters to keep warm, to keep the pipes from freezing.
Sure. Do you get any help with food through the Department of Health and Human Services?
I get $37 a month of food stamps.
37.
And how about Mr. McQuaig?
He doesn't get anything.
Okay.
Okay, this is a sad situation. I mean, I realize he's got an attitude, and that's
So
not appropriate. But
this was a situation where he entered a guilty plea to this charge, and the court assessed only the bare minimum assessments that I had to, and I have to collect them. But I'm sympathetic to the financial situation, but I got to get some payments. So what?
I've been paying a little bit on it each month, and that's all I can do.
Okay.
I've been we've been going out collecting pop cans.
She's confused,
on it. But I intended to keep paying it until I had it paid off. That's all I could do.
All right.
On the charge I had the dog paid, the judge dismissed that case because the dog didn't do any damage. He was just wearing down the joint.
All right.
That's another incident.
Damage whatsoever.
Okay. So it looks like you've been paying $1 here and a couple dollars there.
I've been paying so much each week. Somewhere's between $1 and $2 a month.
Okay. You think we could go up to $10 a month on that?
Huh?
Do you think we could do $10 a month?
Not right now.
Okay.
Because I got medical bills on top of that I haven't even started paying on yet.
All right. What's the most that you can do?
That's the most that I can do right now.
$1 a month?
Whatever I can pick up in bottles and cans that I've been putting on it. But I've been trying to at least pay at least $1 a month, but I've been paying sometimes $2.
All right. We certainly understand that the outstanding balance is over $1,000.
I know. I know.
And at $1 a month, it's.
I know it'll be the rest of my life. That's all I can do, at least to make it an effort to pay them.
Okay. All right. Thank you for your information. Appreciate it.
And I'll continue. Oh, it's not your card.
They'll take that for you. Okay.
I'll hang it up.
Pardon me?
I said I'm getting the wire, so you're through with me then?
Yes. Yep.
I want to see how this ends here. The judge has said he's in a bind, but I'm not sure if he has any flexibility.
All right. So here's what we're going to do, Mr. McQuaig. I am not going to hold you in contempt of court today.
That's good because there's a fine.
I'm going to put you on a payment plan. And if you do not make the payment plan, then you're going to give the court no option but to hold you in contempt of court. I'm going to order that you pay $5 a month. As long as you pay $5 a month, you'll never hear another word from the court.
Well, they're gonna hear from me in federal court. Thanks for extending this 2 years.
All right. So $5 a month going forward, and you won't hear from us again. That's all for today.
Okay, we need to do a little research on this one. realize he's ungrateful, but this is that's a sad situation. Josh, are you able to do any research on this one for me? I'm worried about their phone bill. $350 a month. That's a premium plan on a premium carrier, full unlimited with unlimited internet. If that's 2 cell phones, including the a newer phone on the plan. That's really, really high. $394. Josh, let me know what you find on that. I want to see if there's something we can do there. It puts things in perspective when I'm complaining about my awesome 21-speed mountain bike, the seat not being soft enough for my ride this morning, and other people are saying I'm chopping wood to burn to we've got to buy wood to keep the house from freezing because we can't afford to turn the gas on. That's a perspective wake up call for sure. So I think there's some plans that they could get on with a different phone that would you could even probably keep the same phone number and switch to unlimited everything through Mint Mobile or something else. It might not be the pristine audio quality that you might have through something else, but they need somebody to give them some advice and maybe a little help. Probably includes TV and internet. That's a possibility if there's a cable and phone combination. The free phones don't work well. I agree. You've got to pay a little bit. But okay, we'll do some homework there and see what we can find. All right, we are a little bit away from court beginning. Maybe as much as an hour. It depends on if they start earlier this morning or not up in New Hampshire. Let's see. Go. Okay, just waiting for court there. Yes, Kayla, we're covering Nicole Rice, which doesn't begin until 2 o'clock this afternoon. They've got a late start, so we're going to be covering New Hampshire in the morning, North Dakota in the afternoon. If New Hampshire runs long, we'll probably drop from New Hampshire and pick up Nicole Rice and then rewatch New Hampshire because their schedules are funky. So a lot of them end earlier during the day or something. So we're going to figure out a way to get all the way caught up. But I'm guessing we're probably going to be in a verdict watch here soon. We'll just play it by ear and see what the schedule is for New Hampshire. If I were on the jury in New Hampshire, I'd be frustrated by all the breaks and all the downtime. New Hampshire is not going to run long, I predict, says here. I think it's going to be quick. Do you know why my name no longer shows up in red when someone @s me in chat? Well, Cheryl, let me try it for you. Let's see, Cheryl Ann. You see if that works for you. I just should highlight that for you. If not, it might be a YouTube issue. Nope. Okay, somebody tag me in it. Let's see if it works for me. Could be your browser. Mine shows up in gray on mobile. Mine shows up nice and highlighted in orange for me. It could be a browser thing. If you're watching on a phone, try using the app or try using a different browser to watch on a PC at work. I'm in Chrome, Google Chrome, and that's where it works. Maybe a refresh. YouTube's been having a lot of trouble lately. A ton. Only half day in the ICE trial because her lawyers get to talk to the lead cop this morning. I think, Tony, we're mixing them up. That's the roommate trial, right? Where the defense gets to question the investigator until 1 o'clock today. Fun news this weekend on the podcast. We might be a little bit later than normal. Instead of starting at 8 p.m., we might be starting around 8:30. Weather Watch has a commitment where he's going to be serving up burgers for some friends, and might take us on a field trip, because it's not just in his driveway. We might get to see some animals. So it will be at the petting zoo with Weather Watch is the plan, but it might be a little bit later and it might be a little shorter. Depends on how much time he has. So there's just a heads up. Amber, thank you very much. I did see this. This is a good time to read this while we've got just a moment before trial starts. This is the official notice that came out from the Massachusetts State Police about Trooper Proctor, who was the officer who testified in the Karen Reed trial. Among other things, about looking through her phone for nudes. But Trooper Proctor, this is the official message, through his actions on various dates between January 29th, 2022 and August 17th, 2022, that encompasses the time period when this happened, did fail to conform to the work standards established for a member's rank, title, or position, and did fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. This occurred when Trooper Proctor, while assigned as the lead investigator in a homicide investigation, through his unprofessional and inappropriate conduct, created an image that he was biased in his dealings with a homicide suspect, and or brought otherwise himself and the Massachusetts State Police into disrepute. It sounds like talking about his text messages. This action is in direct violation of Article 5.8.2. This is a Class A violation. Trooper Proctor, on July 19th, 2022, did consume alcohol while on duty and not in the performance of duty. Hang on. Stop for just a second. Did consume alcohol while on duty and not in the performance of duty. Are you saying that there is a consume alcohol while on duty while in the performance of duty for the Massachusetts State Police? Is that what I'm hearing? And while acting under specific orders from a supervisory member or proper authority. This occurred when Trooper Proctor consumed alcoholic beverages while eating dinner on duty and then proceeded to operate his department-issued cruiser. This action is in direct violation of Article 5.10.4. This is a Class B violation. Trooper Michael D. Proctor, ID 3863. As a result of this action, shall A, be terminated / dishonorably discharged. And it's signed official by Jeffrey D. Noble, who's the Colonel Superintendent. There was a buffer there. Make sure you're looking at the 3-pager. I was not looking at the 3-pager. I was looking at the 1-pager. This is the dishonorable discharge page. He's dishonorably discharged. Page 2 is... Oh, we've got more. Hang on, let me go back. I just read three pages. Let me read page 2 for you. The first page is a cover sheet. This is a personnel order. Wednesday, March 19th is the date, which means it was today. It's got the number and a trial board finding. Charge 1, specification 1, guilty. Charge 2, specification 2, guilty. Charge 3, specification guilty. Charge 1 has 3 specifications, guilty on all 3. Charge 2 has 1 specification, guilty on that one as well. So 4 guilties. On that one, it says Trooper Proctor, on various dates between January 29th, 2022 and August 17th, 2022, did fail to conform to the work standards established for the member's rank, title, and or position, and or did fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. This occurred when Trooper Proctor, while assigned as the lead investigator in a homicide investigation, sent derogatory, defamatory, disparaging, and or otherwise inappropriate text messages about a suspect in that investigation to other individuals. This action is in direct violation of Article 5.8.2. This is a Class A violation. Trooper Proctor, on various dates between January 29th, 2022 and June 9th, 2022, did fail to conform to the work standards established for the member's rank, title, or position, and or did fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. This occurred when Trooper Proctor, while assigned as the lead investigator in a homicide investigation, provided sensitive and or confidential information about a homicide victim, potential witnesses, and or potential investigative steps to the investigation to non-law enforcement personnel. This action is a direct violation of Article 5.8.2 as a Class A violation. He gave confidential information to people who were not privy to the information. So those are the other two charges. We read the first two first. And as a result, he will be dishonorably discharged pending an appeal if he chooses to.
When are we going to break for lunch, Judge?
Amber, thank you for that. I appreciate that. We are we're waiting for court to begin here, so it's going to be just a bit. We'll go back to that in a second. Can the defense use that against him? It definitely won't help, especially if he's in court. You know the defense is going to ask, where did you work up until at that time? And he's like, well, Massachusetts State Police. Do you work there now? they'll ask all concerned, like, do you work there now? No, I don't. Oh, when did you leave the service? It was on March 19th, 2027. Oh, just a couple of weeks ago. Oh, are you retired? No retirement. Why no retirement? Didn't you have years of service? Yeah, I was dishonorably discharged. Sorry, I didn't hear that. Can you say that a little louder? I was dishonorably discharged. Oh, you were dishonorable. Why were you dishonorably discharged? You know, this is how it's going to go. Did I say 2027? I said 2025. In my head, I said 2025. Anyway, that's how the back and forth is going to go. They are going to play that up as much as they can. They're going to be like, we need to dig into the whys and hows, because guess what? 4 of those counts cover the time span of this investigation. And as much as it's personnel stuff, we don't want to get into that, and it's not the focus of the case. We're going to have to talk about that in front of the jury. So that's going to happen, and they should. All documents reviewed on this channel are usually on the Discord for public viewing. Yes, thank you, Amber. If you're on Discord, you can find all these generally before I talk about them, even. They appear there first. All right. He must hate it, but you knew this was coming. I mean, you can't... Hang on. Super T. I missed a lot of things. Hang on just one second. Jennifer Juniper, congratulations on 14 months. I appreciate you so much. Love the 14 months. Maureen, welcome to the gallery. Christy G, member for 13 months, says, time flies when having fun. I truly love this community. Thank you, Christy G. Congratulations. You're over the year already. Delina Foster, member for 10 months, says, happy dance. I didn't have to confess being late when I took my seat. I didn't oversleep and caught the hump day. Yell. 1.5 thumbs up. Super T, member for 11 months, member of the jury. Super T, thank you very much for that. Says, prepping for my new shiny hip on the 9th. Love you guys. A new hip on the 9th. You might also get a new courthouse. You're close. You're close. So that's awesome. Good luck with the new hip. I hope it serves you well as you run many marathons. I've heard they work well. Carolyn W., member for 21 months, OG, says, thank you for having such a great channel. Love it here. I'm sorry I missed your messages. I was distracted. It won't happen again. It will, but not for you guys. It will be someone else. Can't imagine losing my pension. Yikes. Yeah. Dishonorable discharge. It's as if you never worked here, sort of thing. We're disowning you. Is Scott's face slightly blurry? It is. Is this better? Just kidding. Let me get it better. How about that? Have a phone call. I don't know who it is.
Call from Bree.
It's Bree. Bree, hello. How are you doing?
Good morning. I'm good. How are you guys?
Fabulous. How's your Wednesday?
Really quick.
Yeah.
It's good. It's cold. New Mexico got real cold. No snow though. Kansas got snow, so I'm good on that.
Yeah.
But I was driving into work, but I heard you talking about Proctor and consuming alcohol on work. the one thing I can think about why that's in there the way that it is a lot of police jurisdictions will do DUI training enforcement. So teaching the cops how they feel when they're impaired, how they drive, like they'll do simulation driving. So I'll have them drink, alcohol to see how they feel after one drink, after two drinks, to figure out how DUI impairs them. So they would be on the clock. I mean, they do it as a training. So, I mean, that's probably why it's written in there that way. That's the only thing it's the only justification I can come up with. But, okay. I mean, it would make sense.
This is true. I've participated in a way in this. I was in a police academy where one of our nights was DUI testing. We're doing breathalyzers. We're trying to spot, the jittery eyes and the delayed movements and the staggering and everything else. And so they said, all right, we'll just need a volunteer to drink. And out of the entire class, nobody either drinks, either we had some alcoholics, nope, I don't touch the stuff, or I'm sober, or we had people who just said, I don't drink, I never have, and nobody was willing to step up and be like, I'll take one for the team, bartender. Nobody would, and so they had to put an ad out in the newspaper. And they're like, we need one volunteer. It turns out like the wife of an officer heard about it. She's like, hey, sign me up, and she shows up. She's like tiny. Okay, like 5'2", weighs nothing, tiny. And the police department, I don't know if they overestimated, how many volunteers they'd have or anything. She shows up and they've got, I don't know, probably 15 or 20 bottles of liquor. They had it down to the liquor store and they got like high-end stuff. They've got like Pappy's, they've got Jack Daniels. It's got everything, just like the full spread. And, one of the officers is like, what do you have? And so he starts serving her drinks, and we're, maybe in between, we're doing all the breathalyzers and timing and stuff like that. And, of course, she got a ride home. But it was funny because they're like, well, I guess they told her, I guess you get to keep all the liquor. We can't really do anything else with it. So she went home with like a full cabinet stocked with various alcoholic beverages. And all she had to do for it was a couple. The next night the police busted up a big party at her house. I'm just kidding. All the police showed up for the party. Anyway, it was quite interesting to watch. And honestly, I'm terrible at spotting any of the symptoms. Like the officer's like, okay, I got 7 on that test, 7 little points where she failed. I'm like, really? She kept her foot up the whole time. I'm not that balanced. I thought she did great. It's like, well, she was slurred speech. Everything's like, I didn't hear it. I would be a terrible DUI cop. Absolutely terrible. I know some cops can just sniff that out, but not me.
Oh yeah. There's a big conspiracy out here in New Mexico. They had a big a ring where the officers are working with some of the defense attorneys. It's big out here. So trust me, they can spot them. They just can't convict them out here. So it's crazy.
Well, Bree, thank you for explaining that. That's probably the only situation where they're allowed to drink on duty.
100%. I just need to know in those situations, do they serve White Claws in red cups and ginger and Jameson? I just need to know.
Yeah.
But we did yesterday figure out what song that they sang, the band. We decided, since they kept talking about Aruba, this song was Kokomo. That must have been what the band was playing at the waterfall.
Jamaica. Ooh, I want to take it. That's a good song. Love the Beach Boys.
It is. It's a great sing-along song, so it all makes sense. It all makes it all come full circle.
Get there fast and we'll take it slow. That's where we want to go, down to Kokomo. Yeah, that's a good one. That's a good one. All right. Thank you, Bree. Appreciate that. It's always good talking to you. Have yourself a fabulous morning.
Talk to you guys later. Bye.
See you. Bye. I need to save her number in my phone because I never can tell when it's her. Okay, so let's see. Add contact. Bree. Okay, there we go. I use a special code so I can see. I added you as a contact. It still doesn't show up. I think I've filled up my contact list. All right. Let's see. How many contacts do you have now? Tons. Like probably close to 500, 700, somewhere in that range. I for months, every time I'd get a call on the burner phone, and I knew who it was, or I got a text message and I knew who it was, I would add their name to the burner phone, to the contact list. Now the burner phone, when I open it, it's like, please, no more, and it just hangs. So I think I've broken it. Greener says, lose my number. You mean this one, Greeners? The one that says 867-5309? No, just kidding. That's not you. All right, we're a little bit away from court. As soon as it starts, we're going to go there. But are you the popular one? No, most people only call me once, and it's a complaint. So, Beach Boys and Beatles are overrated. Changed my mind, says Tom33. The Beatles? Man, that was a movement. Who was doing what the Beatles were doing when the Beatles were doing it? Okay, nowadays, everyone's doing the same thing, right? But they started something. I mean, Elvis started something. No one was doing something with their hips like Elvis was doing with his hips when he was singing. That was unique. Uh-huh. Yeah. Oh, here's another one I should remember.
Call from Sloth Life.
Sloth Life. How is Scotland doing this
morning?
Hi,
Ari. I'm okay, all things considered. I'm just phoning for a wee blather to catch you up on what's going on.
Yeah, how is it?
Unfortunately, my dad got taken back into hospital this morning with chest pains again.
Oh, no.
We actually don't know what's happening. The ECG isn't showing a heart attack, but he's also got other health issues, so they think there's something else going on with his heart, maybe the vessels or whatever. So he's in hospital at the moment. They've got him hooked up to a heart monitor, and we're just waiting to find out what's happening. But I'm Scottish. I get 100 free minutes international calls, and us Scots love to use up anything for free. So I'll just phone and chat.
That's why Scottish people are just prank calling people all around the world. Is that it?
That's it, constant. If I could find other numbers, there would be no hiding for Greeners and Adam.
I can make that happen. Greeners, I just need your approval. Well,
can you imagine?
I'm sorry to hear about that he's back in the hospital. Obviously, prayers for you and him and the whole family.
Yeah, thank you. I mean, I'm doing okay. As I said, 19 months ago, we were told that he wouldn't be here, so every extra day is a blessing. And as we know, I have a bit of a complicated relationship with my dad, but obviously I'm always going to be there for him. So I'm doing okay. My sister's doing all right with it. She's a bit harder to accept the reality of what's going on, but it is what it is, as I say, and I just appreciate every morning that I wake up, so it's a blessing. So anyway,
well, that's a wonderful attitude to have. It still doesn't make it any easier, but we'll be thinking of you for sure.
Oh yeah, I've got you all sitting in the lovely Scottish sunshine with me in the garden.
Are you looking out over the hills, watching the baby haggis roam the fields?
I am. Believe it or not, where I stay, because I'm quite high up, just when you were talking about being above sea level, but where I am, when I look out of my upstairs window, I actually can see Ben Lomond, and I can see the Campsie, the Campsie Hills and all the snow and things. I've got beautiful views from where I am.
Well, send
I can
pictures.
see right across.
Send pictures.
I will. I'll send some pictures. Well, strangely enough, although I get 100 minutes to call, I can't send texts to the burner phone, but I can email probably some pictures.
Email's great.
So
I can't.
I've got lovely views.
My burner phone has 0 international minutes, so I can't text.
That's okay. I don't expect you to text. No, I do. I have lovely views. So we're all sitting in the sunshine, which is quite rare for us. But we've apparently going to be warmer than Spain and Greece. This week we're expected to reach the giddy heights of 20 degrees on Friday. So that's our Scottish summer.
20, you're talking Celsius though, right? So that's about 68 Fahrenheit, if I did my math correctly. 68,
possibly.
70 in that range. I think 21 is 70.
Yeah.
I think that's where it. So
which for March is absolutely great.
I'll take that any day. That's beautiful
Yeah.
weather.
As we say here in Scotland, this will really confuse you. Near cast a clue to me is out.
Is that one word or two? what did you just say?
It's a whole sentence. So near cast a cloot. So
spell
cloot,
that.
C-L-O-O-T.
Okay, cloot. I had to be careful.
Yep. Till me as
oot. I have no idea what any of those words mean.
It is a Scottish expression which means don't throw any of your spring clothes out until May is over. So near cast a clue is never throw your clothes till May is out.
Till May is out.
So until
never throw your clothes till May is over.
Yeah, basically. Yes. Well, not all your clothes, obviously, but your spring or your winter clothes. Sorry, not your spring clothes, your winter clothes.
Okay, I got it. I'll never be able to pronounce that again, but that's a wonderful saying.
Okay, so I'm looking forward to this court case starting and then getting on to the second one too. I have been working in the background, even though I've been off the phone with my dad, etc. this morning. So, but yeah, hope everyone else is doing well and lovely to see everyone in chat.
It's Sloth Life. It's great to hear from you. Have a wonderful day.
You too. You too. And same to everyone else. Speak soon.
Near cast a clue till May is out.
That's right. Near cast a clue till May is out.
All right.
Cheers.
We'll see you.
Bye-bye.
Cheers.
Bye.
PJ, member for 12 months, hit the year mark, says, look how much your channel has grown, Scott. What a blessing you and Mrs. RAR. Thanks for sharing you with all of us. We are family. We are family. Who sang that one? I should know that. Josh, thank you. Let me take a look at that. Near cast a clue till me is out. I'm going to remember that. Near cast a clue till me is out. It's the best accent I've ever pulled off. Okay. All right, thank you, PJ. All right. Near cast a clue till me is out. You might want to confirm the translation before showing it off around town. I just won't say it to any Scottish people, and I should be good. Court, I had to just be clear. Oot equals out. I just had to be clear that I was hearing something different than what I thought I was hearing. New studio, same studio, new setup. It's actually a couple months old now, but we did get a new desk that enables me to have a little bit more close to me, and I've sort of surrounded by screens now, which is always good. Somebody has to, like, I need to text this to myself. Yeah, NBC Boston is reporting it now. Yeah, we read the termination letter a little bit earlier, but yep, he is out, or at least he's on the way out. He may still appeal. I don't think he would win. He's got 4 guilties against him, and one of them was drunk driving in a police car. That's a big one. Police look at that. If you get caught doing that, I guess, especially in the Canton area, if you get caught doing that, it's really frowned upon. You should not get caught drunk driving in a police car. I think that's the policy. Don't get caught. And he was. So that was bad. Shark says, just confirmed the translation. She didn't do you dirty. Good. Yes, I did say 2027. It's 2025. I want to skip a couple years. Today started off so bad. Or this year did, anyway. In England, they say it like this. Never shed a clout till May is out. Near cast a clute till May is out. But it was Canton. He got caught. And Melanie, I apologize. I think you might have been watching a little bit on delay. I was asking how to get to your community page yesterday. And right after I ended in chat, came up 3 times, my channel, my name's my channel. So I apologize. But thank you for posting. I can't remember what it was now. My memory's short. But all right. Is that near Casticlut till Meazut have anything to do with don't wear white after Labor Day or something? Is that of the same level of saying? What's the new Proctor that he's been dishonorably discharged from the Massachusetts State Police for 4 counts? Basically sending texts about Karen Reed, disparaging texts, giving confidential information about a suspect to someone who has no right or reason to have that information, driving drunk in a police car on duty, things like that. Not, the red Solo Cups was not mentioned, nor was planting evidence or anything else. That was not in there. So, does anyone know if and when Melody Ferris appeals trial? I don't know. Usually it's about 6 months at the soonest from a trial like that before transcripts are ready. And you need a transcript for an appeal so that the appellate judges can look at everything. So it's like a minimum of 6 months. Although usually they have to file a notice of appeal within the first 30 days or so. Oh, yeah, it was about the Cold Justice show about the unaliving in North Dakota. Thank you. Thank you for the link to that, Melanie. The Cold Justice show is the reason why we have the trial we have in the afternoon out of North Dakota, that cold case for the roommates charged with murder now. Is Weatherwatch being committed to the asylum? No. He's not going to the funny farm. He's just going to the farm, the petting zoo, for the podcast tomorrow. Weatherwatch petting zoo edition is what we're going to get. Petting zoo and barbecue, which I guess if there are cows on the farm and he's cooking beef, I guess that, I don't know. I think it's fitting. You source your food as close to the source as possible, right? You're behind in the video. Late comment. It's all right. He's going to Chloe's farm and VT. No, he's not. How much will it cost to pet Weatherwatch? That is a question you'll have to forward to him and his wife. I'm pretty sure the answer is not going to be a dollar amount. It's going to be probably in the negatory category. We're going on a field trip. We are. All right, we're waiting for court to start. It's due here in about 20 minutes. So if anybody has any questions about court, we've done a little wrap up about what's happened. We're also hang on. I got the information from Josh as well that I was looking for. It's in the case we watched this morning with the gentleman who is in a financial distress and has a court fine of about $1,000. It's out of Michigan, 27th Circuit Court, Newaygo, White Cloud area. Motion in order to show cause. The charge was assaulting a police officer, and obstructing or causing injury. There was no jail time ordered. It stems from a disturbing the peace. which would probably indicate that there might have been some drinking involved. See if there's anything else. Let's see, 5 days jail was ordered previously for looks like a DUI. Man. That's a lot of peace. Did you see Judge Middleton called someone's mom this morning to try to track them down before he issued a warrant for skipping court? I love, what's funny about that is Judge Middleton probably knows the defendant and the mom. And anyway, let's... He
has not been afforded the right to confront his accuser.
Hang on one second. We're beginning.
Video.
Hang on one second right now. So, all right, hold tight. Court starting. Here we go. It started like cold turkey, just like threw us right in the middle of it. I can already tell you the argument they're about to make. I don't think will fly because they can call him.
All right, so we are back on the record in the state of New Hampshire versus Jason Levesque. This is 2024 CR 273. Counsel, yesterday the state rested. Attorney Sisti, do you have a motion to make at this point?
State rested.
I do, Your Honor. Thank you for the opportunity. First of all, I'd like to incorporate all the arguments that related to the motion to dismiss that's already filed.
Yes, of course.
You had alluded to that earlier. The state has rested. Self-defense, deadly force is still viable. And we would set forth that the prosecution has not negated it at this juncture. There hasn't been adequate response with regard to that position, whether it's being reflected in statements of both Jason and his daughter or reflected in the video. The last witness, in fact, confirmed that Jason would have been accurate by stating that it appears from the statement in the video that Violet initiated contact, that Violet stuck his face into Jason's face, that there were threats made, that Violet appeared agitated and upset. I'd also note that I'm going to bring back one other issue here, and that's the missing witness. I know it's been litigated, but the state has rested, and it is now 10:41 a.m. On the 19th of March, in his trial, and he has not been afforded the right to confront his accuser face-to-face at this trial, contrary to the Sixth Amendment of the U.S. Constitution, Part 1, Article 15 of the New Hampshire Constitution. That's an essential right. It's nothing new. It's been articulated over and over again from the beginning of our nation. I'd also state that there are insufficient facts that have been adduced by the state to counter the claim of self-defense, thereby defeating the criminal element, the critical element of the case, and that being the state must disprove self-defense beyond a reasonable doubt. And what I'll do is I'll ask the court to incorporate its proposed self-defense instruction with regard to that. I need not be every word of that, but I ask the court to reflect, or actually the record to reflect. We do have a proposed instruction on self-defense. I expect that will be one that we are working with. If I need to have that mark now, and would. But I think all parties would agree that's what we're going to do on here. There hasn't been any objection to it, although I have to say you do have one minor mistake on it.
Which we can take up after this argument. I'm happy to hear that. Actually, that raises something because overnight I went through my jury instructions and made some adjustments to the self-defense instruction, which I need to share with both parties before we get to that part of the proceeding. Specifically, I'm going to add, I think it makes sense, and we can talk about this more. The self-defense instruction references serious bodily injury, but never defines serious bodily injury. And elsewhere in the instructions, I define bodily injury because of the First Amendment, the first degree assault. I think it makes sense if I'm going to say something about serious bodily injury in the self-defense instructions that I should define serious bodily injury. So I've added some language defining serious bodily injury, and I've also just changed a little bit of the phrasing for grammatical, editorial reasons. But I want you to see that before we get to instructions. So we'll make sure there's time for that. So go ahead, counsel. I'm sorry.
So specifically, I'd like that incorporated. Next up, let's just move on to the attempted murder aspect. Again, I think there's a flaw there with regard to the mens rea. It requires, with regard to that particular charge, the information, videos, and testimony indicate that we're dealing with a reaction not initiated by Jason to the actions of the alleged victim, which would fail to establish that Jason had requisite mental state at the time of the shooting, and would also establish that he didn't have the purposeful intent to kill at the time. I know that there is after the fact video that's been introduced at this trial, but the after the fact video does not necessarily reflect the instantaneous reaction of an individual to his position. And then I'll just incorporate the self-defense argument that I've already made with regard to the first degree assault indictment. Those are the basic areas that I'd ask the court to reflect upon and would ask for dismissal of both indictments.
Thank you. State.
Thank you, Your Honor. Specifically regarding the self-defense argument that the defense has raised, and I think it's important we remember that the view the court is to take in this moment is in the light most favorable to the state and reasonable facts and inferences in that view. A reasonable jury could absolutely find that the state has overcome defense's affirmative defense of self-defense in this particular case. The jury has seen numerous videos in this case that demonstrate that any kind of altercation that was previously going on between the defendant and Mr. Violet, any kind of previous interaction outside in front of the plow, had ended at the point wherein the defendant pulled out his gun and aimed it at Kyle Violet. They were many feet apart at that point by all estimations, other than I believe the defendants the night of, 15 feet or more away from each other. Mr. Violet was going back into his own home. By Detective Daney's testimony, which the jury did hear, you can actually see in the shadows the way that his feet were turning. So even after he had turned back to look at the defendant, the victim's feet were moving in a way that he was turning further away after he saw the defendant pull out his gun. The altercation had been ended at that point. It's in this moment that the defendant shot Mr. Violet the first time, which hit him in the face. He then proceeded to shoot him 5 more times while Mr. Violet crawled on the ground. But that 5 more times didn't occur until after about 3 or 4 second pause. And during that pause, the defendant actually put the gun down, paused, and took several steps forward in order to get closer to Mr. Violet in order to shoot him, presumably more accurately. But in order to, when those shots were happening, he was stepping, in fact, closer to Mr. Violet while he crawled on the ground. Regarding the mental state in this matter, that can truly only be indicative of a purpose. As Your Honor is aware, mental state can be established, to use defense's word, instantaneously. This does not have to be a premeditated thought that days before, weeks before, even minutes before he decided to shoot Mr. Violet, the defendant made that conscious decision. It can be a decision that is decided in an instant, and in this case, I do believe that is what we are talking about. I'd also refer, Your Honor, to specifically the self-defense statute 627-4, which states a person is justified in using deadly force upon another person when he reasonably believes that such other person is about to use unlawful deadly force against the actor or a third person. Specifically regarding, that does seem to be the main focus here. There are additional other times where the statute allows for it, but that seems to be the major issue here, is there's no issue of burglary or kidnapping or anything along those lines. There has been no allegation that Mr. Violet had a weapon. The detectives have already said that he did not have one when they got there. The officers that responded stated that when they were performing the medical aid, they did not see a gun on him. They did not see any kind of weapon on him. The defendant himself, as you heard through Detective Garson yesterday, stated that Mr. Violet's hands were empty when he was walking over to the plow area and while they were having that conversation. He stated he did not think Mr. Violet had a weapon. The defendant's own daughter stated that she did not think that he had a weapon. She had no reason to think that he did. So all we're talking about in this moment are words. That, when viewed with the timing issue here of Mr. Violet turning and walking away back towards his own home, there is no imminent deadly threat. And a reasonable jury could have found that the state has proved that and thus overcome the self-defense issue. The other portion of the self-defense statute I want to refer Your Honor to is that a person is not justified in using deadly force, this is Roman numeral 3, on another to defend himself or herself or a third person from deadly force by the other. They know that they can with complete safety comply with demand that they abstain from performing an act which they're not obligated to perform. That's a conditional threat. All of the testimony about an alleged threat made by Mr. Violet include the language, if you do this, I'm going to do this. If you keep plowing the fucking snow in front of my driveway, I'm going to kill your family, is the threat that we've heard time and time again in this particular case. That is the definition of a conditional threat, Your Honor. If X, then Y. And both the defendant's daughter and the defendant were consistent in their statements to police when they were describing any kind of potentially alleged threat occurred. That being a conditional threat, and the jury hearing Your Honor's instruction about it, as well as ultimately as the case goes on, a reasonable jury could find that because this threat was conditional, that self-defense is not justified in this particular case, especially when viewed with the fact that when that deadly force is viewed with it, where there was no allegation of any kind of weapon, any kind of specific aggressive action toward any particular person in this case, other than getting close in physical proximity. There wasn't strangulation, there wasn't a hit. I'd also refer to Your Honor, the only threats that, the only physical risk that the defendant was able to articulate in his statement to police was a fear that that Mr. Violet might hit him, or that he might move forward to him and potentially take the gun away from him when he had pulled this gun. That is not an imminent deadly threat or threat of serious bodily injury, just on its face. A threat to a punch is not facially serious bodily injury. The jury's heard not quite extensive, but I think accurate and voluminous testimony at this point about the injuries suffered by Mr. Violet at this case. So to the extent that the risk of death is an issue, which I don't believe it is, I didn't raise it, but for the record, we'll make that argument. That has been more than covered by Dr. Priest, who was able to articulate the 3 different hospitals that Mr. Violet went to.
Surprised the response has taken this long.
That night, and then ultimately spending several weeks at Boston Memorial, where he underwent multiple surgeries.
What if they're
we were
worried?
able to hear from Detective Daney, who collected one of the bullets that was retrieved through Mr. Violet's face after he underwent surgery. At that point, they were able to see the body camera footage of Sergeant Williams Hurley, who was performing the life-saving medical treatment, as well as her testimony from the paramedic in this case, all of whom described the very serious nature of these injuries that Mr. Violet was suffering, and articulated that if not for this intervening medical treatment, he would have died. So that element is absolutely established at this point by the state, Your Honor. Just one moment.
Normally this response is quite
it's for those
brief.
reasons, Your Honor, that the state does believe a reasonable jury could find, in the light most favorable to the state, that not only has the state proven these charges beyond a reasonable doubt, but that we have actually overcome defense's self-defense claim by defending guilty.
Okay.
I think the judge is on board there.
Very briefly.
Okay.
course, the court knows that there's no need for a defendant to have been found. Interesting argument. It's also irrelevant. Not actually, it's not a fact that's in any contention. With regard to Kara Levesque's testimony, she did state that she felt threatened and that they were in danger. And that's uncontradicted. I'll also state that physical motion, physical activity can act as threats. Those would include surprising somebody coming up on them without notice and physically sticking their face in their face, unprovoked and uninvited. And in total context of the situation, this not only was not a conditional threat, it was actual physical threat. And with an actual physical threat, we did not dance around conditional or otherwise. But there has been information produced that, in fact, Kira, in her testimony, stated that there was an actual threat. She sensed it. So with that, Your Honor, I will rest on it.
Okay, thank you. Having heard from both parties, having reviewed the evidence in this case myself, I'm going to deny the motion. I think viewing all of the evidence in the light most favorable to the state, as I'm required to do at this point, and drawing all reasonable inferences from that evidence, as I'm required to do at this point, I believe that a rational juror could find the defendant guilty beyond a reasonable doubt. I think the state has presented enough evidence, even without the victim in this case, to be able to potentially disprove self-defense. I think a jury could have doubt about all three of the prongs, basically, of the self-defense instruction. That is, whether the defendant actually believed that there was an imminent threat of serious bodily injury. I think the jury could conclude, based on this evidence, that even if he did believe that there was such a risk, that it wasn't reasonable. And I think a jury could also conclude, based on the evidence, that even if he reasonably believed that he needed to use force, that the amount of force was excessive. I base that upon primarily the video evidence, which I think is probably the most striking aspect of this case. I mean, when you look at the video evidence, you can clearly see that there is some sort of altercation, that the alleged victim is acting in a hostile, aggressive way toward the defendant. I think it's not a stretch to say that from that evidence you can see that the defendant is likely in fear that he's potentially going to be in a physical fight with the victim, that a physical fight is about to break out and he might be attacked. But I think when you look at all of the video evidence, and in particular the way the shooting actually unfolds in terms of when the defendant draws the weapon, you can see the victim appears to be turning to walk away when that first shot is fired. The fact that there's the three approximately second delay, at which point I think a jury could conclude the defendant did have an opportunity to think about the situation, to reflect for a moment. At that point, the video shows the victim crawling away from the defendant, at which point the defendant takes several steps towards him, raises the gun a second time and fires 5 additional bullets. There's the medical testimony that suggests that all 5 of those shots struck the victim in the back.
Yeah.
There is no evidence that the victim possessed a weapon, or that he appeared to be reaching for a weapon, that there was any evidence from which the jury could conclude that the defendant thought that the defendant was about to, say, shoot back at him. I think given all that evidence in its totality, viewing it in the light most favorable to the state, as I'm required to do at this point, drawing all reasonable inferences in the state's favor, as I'm required to do at this point, I think a rational juror looking at all the evidence could find that the state has disproven self-defense. As for the other elements, I think the mens rea element of the attempted murder case, I think the fact that the defendant then fires 5 additional bullets into the defendant into his back, basically, while he's crawling away from him, is sufficient evidence from which a rational juror could conclude that he had the purpose to commit murder. That is, that he had the purpose to kill the defendant, kill the alleged victim. In terms of the first-degree assault, I don't think there's really any doubt that there's really no question from the evidence presented that the defendant did in fact cause bodily injury to the victim using a deadly weapon. I don't think that's really even in dispute. So the only issue on the first-degree assault case is the self-defense, and that, as I've already said, I think a rational juror could conclude that self-defense has been disproven beyond a reasonable doubt by the state. So for all those reasons, I'm going to deny the motion.
Maybe think about a plea deal.
And at that point, I think, are we ready to bring the jury back?
I'd like to renew a motion in anticipation of the defendant testifying. We talked about the limitation of the defendant to inquire on cross-examination about a prior, refer to it as a prior incident or prior threat allegedly made by Kyle Violet towards the defendant.
Oh, that's got to come in if he takes the stand.
And now I'd like to focus on whether the defendant actually has the right under the rules of evidence to testify to that event. My position is that analytically it doesn't change, that I'm certainly aware that in self-defense cases, instances of pertinent character traits known to the defendant can be addressed. I don't think that rule changes the analysis between how that evidence comes in, as opinion evidence and non-specific instances. I also would raise a 403 issue on this particular prior threat. Here's the basic claim that Jason Levesque made during that police interrogation or questioning. He said, probably 2 months ago, but then when asked for some type of framework, he said, well, it was in the fall. It may be early winter. That would be like November. He was out doing some chore on his porch. He says that that Kyle walks by and calls him a rat and says, if you call the police again, I'm going to fucking kill you and your family, invoking the exact same threat. But what he says transpires next is absolutely nothing. In other words, even assuming that there was a threat made some 6 to 4 months earlier, the relevance of that in terms of a self-defense claim against the use of deadly force is highly attenuated, but still quite prejudicial, and unfairly so. Because it's not a character trait for the actual use of force. It's apparently a character trait for mouthing off in similar fashion. If you do something, I'm going to fucking kill you and your family. That has very low probative value, and in fact, even assuming it's true, it doesn't change the dial on his ability to use deadly force in a given instance some 6 to 4 months later. And for that reason, I object even to the defendant.
I think the judge should overrule this.
Thank you. Attorney Sisti?
Jason's going to take the stand. We expect to go into that claim. That's one of the factors that was going through his head at the time. And he explained that. This is an interview. You know we've been barred on hearsay. This is not hearsay. This is what he actually experienced. And I think we've actually discussed this at the bench. In fact, my understanding from the court was certainly incumbent to the defendant if he takes a stand and not to the investigating detective to his type of a hearsay exception. And I don't agree with that right now. And we're prepared to come to the stand and elicit all relevant information as to why he thought at the time, on April 4th, that he had acted self-defense, and that he did have contact with Mr. Violet. Certainly wasn't pleasant, and in fact it involved an actual threat to him and his family, much like that, which took place on April 4th. So yes, it's relevant, it comes in, it's an instance that does have an impact on how he operated and how he dealt with the situation on April 4th. And I certainly will, agree this juncture. And it wipes out any issue, I take it, with regard to your rulings under 803, 801. Today, we're in another ballpark. How he felt, what he experienced, and how he can firsthand explain his interactions with Kyle Fowler.
All right, thank you. So the court, anticipating this issue, has done some research. I am going to deny the state's motion at this point, in part. I'm relying on cases, the following cases. I'm relying on State versus Woodburn, which is a 2023 case of the New Hampshire Supreme Court. This is 175 New Hampshire 645. I'm relying on State versus Vassar, a 2006 case, 154 New Hampshire 370. Both of those cases stand for the proposition that in cases where self-defense is raised, that the state of mind of the defendant is an important factor that the jury has to decide, and that under 404B, prior bad acts may be relevant for purposes of determining the defendant's state of mind at the time of the incident and whether he was reasonably in fear. If you look at State v. Woodburn specifically, they lay out the tests that the court should apply in applying 404B in these circumstances. And to ensure that the prior bad acts are relevant for a non-propensity purpose, the proponent must demonstrate a sufficient logical connection between the prior acts, and the defendant's state of mind at the time of the charged conduct. The temporal proximity or remoteness is one factor which the court can consider in deciding whether there's a sufficient logical connection that exists. But both of those cases stand for the proposition that defendant's state of mind in terms of self-defense is an appropriate non-propensity reason to bring in prior bad acts under 404B. Now that does raise the question which the state raised last time we talked about this, which was that my understanding is that 404B notice was never given in this case, which is a requirement in order to use 404B evidence. Normally there has to be notice to the state. The purposes of that notice requirement is to give the state an opportunity to, if they choose to file a motion in limine, or to do additional discovery. Now, on the other side of that calculus, the state clearly was aware of these.
Judge, on the notice issue, the state waived.
Okay, I was about to get to that. I think the state had notice of these statements, knew about them all along. So I am going to limit it to the extent that the defense intends to introduce prior bad acts by the alleged victim that go to the defendant's state of mind. I think they're limited to those which have been previously disclosed in the defendant's statement. They're not to go beyond the four corners of the statement that's been previously provided to the state. I did review Newell as well, counsel. I looked at it. I think that's a slightly different issue there. Newell is focused on the character evidence side of this. In that case involved a prior criminal conviction that they were trying to bring in to show character specifically. It wasn't dealing specifically with prior bad acts directed at the defendant by the same victim. And that Woodburn is on point.
If it's French, it's livernois.
Right. So with that,
livernois.
I'm sorry? Yes, please.
All right, so quick approach. We have learned that the defendant is going to take the stand. He's a little bit mad because he can't face his accuser, meaning he can't face the victim again. Victim has no desire to do that. And judge says it's not an issue. Not an issue here. The state's your accuser. So the state then moved to restrict the defendant from talking about prior bad acts with the victim. They won that successfully on their case, keeping the rule of completeness argument at bay during the interrogation, because they did bring up prior bad acts during the interrogation. That was kept out, but now once he takes the stand, he can testify to what he experienced. The judge ruled in part, overruled the state's motion that he can't bring this up and said, yes, you can bring it up, but he can only bring up the stuff you've already talked about, the things that have already come up. I can't let you take a stand make up 50
We're going to take a
stories.
5-minute recess. We're then going to bring the jury out, and we're going to start with the state's case, defense case. Very good.
Okay, so a day wouldn't be the day unless we take a recess. So we're going to take a quick break, skip ahead, and we've got about a minute left to wait for court to begin. Quick recess. This is not looking good for him, honestly. This is, if there's a plea deal on the table, even if it's not a good one, the defense knows one thing that I don't. They know what the jury looks like. They know if they're sympathetic to the cause. They sat through voir dire. They know if there's a whole bunch of people who have bad neighbors that are on the jury who wish they could have done something about it. They might have a sympathetic jury. That would be the only reason I'd say you want to proceed here. You'd be better off pleading guilty, and even at this late stage, and having the judge sentence you. I think if a plea deal's on the table, I would definitely consider that at this point. Judge may be a chain smoker. We've discussed that. Or he's not a camel. Did they get to bring in the defendant's bad prior act? Defendants? Ooh, that's an interesting question. I don't know if they talk about the character of the victim. I'm not sure if they're able to talk about the character of the defendant. That might be to prejudice. But this particular bad act was a almost verbatim threat that matched the incident in question. So I think that's why they're allowed to bring this one in. I don't think they'd be able to get into the defendant's prior DV, at least until sentencing, and then that could probably be considered. We have no idea if he smokes or not. We just give him a hard time, but lots of breaks. Thou shalt hold a bunny. That's the rule of this court. Come be a jury member, do your civic duty, and sit in the back room 90% of the trial. Come on down. Yes. Earn your $8 an hour or day, depending on the trial. Prosecutor might not have offered one, but they can give a time frame for which it is available. They can. But at this point, they've basically proven their case. Things went about as well as they can possibly go for the prosecution. As far as what they were allowed to bring in, the evidence, what believe they've proven with evidence in front of the jury, and what the defense was not allowed to bring in as far as distraction goes. So there's not a lot of incentive for the state to say, okay, we'll cut a deal just to make sure we get a conviction. Didn't judge instruct prosecutors to provide a doctor's note for Kyle not testifying? He did. We did not hear the outcome of that. That may have been handled in chambers. But that may have been the reason why we heard this morning the argument for the Sixth Amendment, that he's not allowed to face his accuser, that's a violation of his rights. That may have been why we heard that. The judge dismissed that. You can take a plea basically right up until you're sentenced, but only if the prosecution continues to offer it. And the ball is in their court. They could offer you a plea deal and say, you've got 5 minutes, take it or leave it. And if you don't take it, it's gone. Where's he going now? Oh, he's taking a stand. No cuffs. That suit is part trench coat. Yeah, the judge sometimes does not have to accept your plea deal. I think that might always be the case. Jason up there on the stand, getting the lay of the land, seeing the courtroom from a different perspective. Looks a little bit nervous. His lawyer's not looking too optimistic either. But one thing we can count on is that cursive counter is going to go up, up, up during this testimony. He's on the stand. He is ready to testify. He has not been sworn in yet. We're waiting for the jury to come in, the judge to come back, and at that point he'll be sworn in, and we'll proceed with the defense case with him as their first witness. Jasmine, I agree. I can't. Well, I can see why they're doing that, but at the same time, in this particular case, I think it might hurt him. I mean, he's got to have a very believable story for something that everyone else saw on video.
Thank you. You all may be seated.
Clear.
My understanding is that the jury is being assembled. It just may be a minute or two, so we'll all jump back up in a minute.
Myron, you were right. The counter is for bad words. I realize cursive.
Jury instructions.
Cursive is handwriting. And curses are different.
Can you give one of these to Attorney Siskey's side?
But cursing I sometimes refer to as flowery language, and cursive is flowery handwriting. So I just did a play on words and called it the cursive counter, because the F-bomb counter didn't look very professional in the corner. I imagine they have a ram's horn that they blow in the hallway that summons the jury. Like that, you know, the big one. Big old full curl.
As soon as they're ready, they can come in. Yeah.
I think the spiciest part will be cross-examination, and I think it's going to be the...
Please rise, jury entering.
I think it's going to be the male prosecutor that has a bit of fire in him that'll do the cross.
Please be seated.
Good morning, ladies and gentlemen.
Voice cracks.
Thank you for all being prompt this morning and being on time. Sorry we weren't able to start right on time, but these things happen. As I told you at the close yesterday, the defendant is not required to put on a defense if he doesn't choose to, but in this case I'm being told the defense has opted to put on a defense, and my understanding is that the first witness that they're going to call is the defendant himself, and so we are ready to proceed. Counsel, you may inquire.
Thank you very much, Your Honor.
Swear him in.
Swear. Jason in full.
My goodness. You're right. You raise your right hand. You swear that any testimony you're about to give will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury. I do. You may be seated.
Thought about that one.
And just try to keep your voice up so everyone can hear you.
Yes, Your Honor. Can everybody hear me? Thank you.
First, let me get through some formalities
Pleasantries.
here. Just state your name and spell your last name for the jury, please.
My name is Jason Levesque, Levesque.
The S is silent.
And you just heard the judge explain that, of course, we don't have the burden to put on any evidence.
Yes.
Are you freely, voluntarily wanting to testify for this jury today?
Yes, sir.
I'm going to ask you some background questions so the jury gets to know you a little bit. Where were you born?
I was born in Rochester, New Hampshire at Frisbee Memorial Hospital.
And have you lived in this area all your life?
All 45 years.
Who else lives in the Rochester area?
My daughter, she resides with me.
Everybody?
And my two parents, they live downstairs at my house.
The jury went out on a view, you know that, you were with us. And your house is which number?
My house is number 41 Summer Street.
Okay. And just again for the record, could you describe it so everybody has a clear picture of what we're talking about?
As in the property?
Yeah.
My house was the one when we were coming from the traffic lights. It would be the first house that we viewed, with the front porch, with the steps. The driveway's to the right-hand side. There's some landscaping out front. There's a fence that directly follows the right-hand side of my driveway, and there's a garage at the back.
And again, you stated that your daughter lives with you and your parents. And can you give us some position? Where would your parents be in that house if the jury's looking at it square?
If you're looking at the front of the house, it's a duplex, and my parents live downstairs. So they're getting older, so we put it that way. That way they don't have to deal with any stairs. And my daughter and I reside upstairs in the upstairs apartment.
Okay. And I guess there was a porch area there and steps that go up to the porch area of the house?
That is correct. The front entry is on the front of the house where there's a porch, and the front steps go up to the front door, which you can access both the upstairs and downstairs.
All right, so we're going to get to that positioning in a few minutes, but I just want to make it clear it's your parents that live right there, right basically on the street.
That's correct. Their bedroom is the front room of that downstairs apartment. Their bed's right there at the window.
Now, you mentioned your daughter. What's her name?
Her name is Kira.
And how old is she?
She is 20 years old.
Can you give us a little history with her? I tell you, you're a single father?
I am.
And, how long have you and Kara been a team?
I received sole custody of my daughter when she was approximately 16 years old. She's lived with me all her life. We've always lived together. However, there is some issues with her mother, and her mother's left the house, and I received sole custody of her, I believe, approximately 15 or 16. It was 2019.
And she's been with you exclusively since then?
Yes.
And, can you generally just tell the jury what kind of relationship you have with her?
Sorry. My daughter and I have a very close relationship ever since she was a young child. She would go out with me when I was doing heating. She would on call with me, or if we were plowing, she'd go out plowing with me.
You okay?
She used to operate the plow for me even when she was younger. She used to find great fun in that. As she got older, she started working. So she didn't want to drive. She had a little accident when she was learning how to drive, went through my parents' garage door at their previous house. So until she was 18, she didn't get a license. So I had to drive her back and forth to Rye every day for her job. Also, when she was in high school, she did an internship as a teacher at an elementary school in town. So I used to have to drive her there every day. Her and I were very close. Always have been.
Where did she go to school?
She went to elementary school at Chamberlain Street School in Rochester, then to Rochester Middle School. Then she graduated Spalding in, I believe it was 2 years ago. I think it was 2022. And then she moved on to Southern New Hampshire University. Right now she's taking a pause from college, but I believe she's enrolled to start at the University of Arkansas.
Very proud of her.
I am very proud of her. Sorry.
You talked about your neighbors a little bit, okay?
Okay.
The jury has heard a couple of folks, just two of them that live next door to you. Did you have any kind of relationship with your neighbors?
Blinks are speeding up.
Which ones?
Well, let's go through Kyle's daughter took the stand. You saw her.
I did, yes.
Did you know her or have any interaction with her ever before?
I did not know that there was a young female living there, no.
And again, how long have you lived in that house?
I lived in that house 20 years.
20 years.
Yep.
And then you saw, I think she's referred to as Kyle's girlfriend, the mother of the child. You saw her testify as well.
That's correct.
Did you have any interaction with her?
I did not have any interaction. However, I did know that she did live there. I frequently saw her coming and going.
But not even a hello or anything like that?
No.
Now, I want to ask you about the other person that lived there, and that's Kyle himself. Did you have any kind of relationship with him?
Before that evening, I did have one interaction. That would be in sometime, probably October or November. In the fall, I was out front pressure washing my house, and a gentleman came out of that driveway, was running around, acting kind of crazy, looked at me and said, "You fucking rat, I'll kill you and your family."
Okay, let's hold on here a second.
Yeah, hold on.
October, November of 2023, correct?
Yes, sir.
And you were in front of your house doing some chore?
Yes.
Had you had any kind of contact that would have elicited that kind of reaction from him prior to him coming over and confronting you?
No, I did not even know that he lived there. I'd only seen his girlfriend, or Angela, was the only person I'd ever seen coming and going from there.
And again, explain to the jury just what this guy did.
He was running around in his driveway very erratically, and said, "You fucking rat, I'm gonna kill you and your family." It just kept moving back and forth. So at that point, I decided it was just best to go in the house and leave the situation, not to antagonize him or even engage with him, not knowing who he was or what was going on. I then went inside and told my parents, just keep the blinds closed on that side of the house. Hopefully he'll just leave us alone after that.
Right, so you went inside and you informed your folks of that?
That's correct.
And did something happen just shortly after that as well?
Later on that evening, I was outside working in my garage. I had exited the garage to go into the house, and he and another gentleman were walking by. He came into the driveway and said, "You fucking rat, I'm going to kill you and your family." At that time, I went back into the garage and closed the door to, again, not engage with him.
Apparently, he only has one threat.
I mean, we've heard that. I mean, was that a threat towards you?
Yes.
And your family?
Yes.
Nothing conditional about that?
No, sir.
And did you understand it as a threat?
I did.
And how did that impact you? How did that stay with you?
It made me nervous. At that point, after that, I installed some security lights, some security cameras. That way I could keep an eye on things, and I didn't know who he was or what it was with him that he didn't like me, but I wanted to be more vigilant after that to make sure I was aware of my surroundings.
So after that, what did you do?
I installed some security cameras and some security lights, motion lights, so if somebody comes on my property, it lights up at night so I can see there's somebody there.
Now, we pointed out some cameras at your place when the jury was taking a view. Were those some of the cameras you installed because of that event?
Yes, I installed 12 cameras, 2 1-terabyte hard drives. Each camera is covered by another camera, and every entry to the house is covered by a camera.
Now he's speaking my language.
And that was triggered because of that content?
Yes, sir.
Did you also alter any behavior with regard to your daughter?
I did.
Explain that.
After that, my daughter, she works at the pizza place. She had been driving at this point. She comes home at night. She had been aware of the altercation. I was concerned, and she was concerned about coming in the front door, seeing as the property's right there. So she would call me when she was on her way home, and I'd meet her at the door and make sure, or go out to the car and make sure she got in the house safely.
Sherry, congratulations.
Basically, we're escorting her in after work.
That is correct.
She would call you in the driveway, and you'd go down and get her.
She typically called me coming down Eastern Avenue, which is the road right there by the post office.
Okay. And then you meet her outside?
That's correct.
Okay, let me jump to, I'm actually going to jump to April 3rd. We've been hearing a lot about April 4th, but wow, but your day actually started April 3rd, and it was continuing, right?
That is correct.
So why don't you explain to the jury about what time did you get up on April 3rd, the day before the shooting?
I woke up around, I believe, 8 o'clock. I had some breakfast. I was redoing my dining room, doing floor and painting. I wanted to try and get the painting done before I went to work. I knew that snow was coming, However, we had not got a time that we were supposed to start yet. So I pretty much took the day and I finished cutting in all the dining room and doing the painting around there. It was approximately 6 o'clock in the evening. I received a text from my boss saying, looks like start time is going to be 10 p.m. I'd like you to do what we call a sniffer route, go around and start driving through the properties, seeing if there's snow accumulating on the ground, and seeing when we should start calling in other people to take care of those properties.
Okay, so between 8 and 6 in the evening on the 3rd, had you taken a nap or rested or anything like that?
No, I did not. I anticipated the snow starting much later, so I figured I'd have some time, but I didn't really have time. After he called, I needed to clean up all my supplies, have something to eat, and get ready.
All right. So at or around 10 o'clock, what do you do?
10 o'clock, just before 10 o'clock, I'd say maybe quarter of, I take my vehicle out of the garage. I put my parents' vehicle in the garage so they don't have to worry about cleaning snow off of it. Then I drive to Home Depot where my plow truck is parked behind there where our salt shed is. I start my truck. I go over my pre-trip inspection to make sure my truck's safe for operation, make sure it has oil in it, coolant, windshield washer fluid. I then go over and start the front end loader. I let that warm up. I go in, I log into my tablet so I can log into the application site photos, which keeps track of my time card. It also keeps track of where I am plowing and salting. I then went to the loader. I grabbed 2-3 buckets of salt. I filled up my truck, covered over the salt, made contact with my boss, let him know I was ready to go. He said, all right, start running your route.
Okay. Up until that point in time, had you gotten any sleep?
No, sir.
Sounds like it was very active at the beginning at 10 o'clock.
Yes. Yeah.
Who do you work for, by the way? I don't know if we ever covered this.
I work for North Atlantic Snow.
And how long have you been working for them?
This would have been last year was my 3rd season.
3rd season?
That's correct.
Snow plowing in the winter and snow cones
when
in the summer.
When it's not snowing, how do you make a living?
When it's not snowing, I do car audio and electronic installs.
That's a surprise.
Where do you do that?
I do some on the side at my house. I also work from time to time for Speed of Sound in Somersworth.
He's an audio guy.
All right.
He's tech.
So, what was your agenda starting at 10 o'clock? What were your jobs? Give the jury an idea of what you do. I mean, most of us are in bed when you guys are out doing this.
Correct.
Right. What's going on?
So we do all commercial application or commercial properties. We do big box stores, like I said, we start at Home Depot. We also have government, we do district courts. We do healthcare facilities. We do urgent cares, hospitals. We do pharmacies, Walgreens. We do gas stations. We have Cumberland Farms. We have Irving. We have auto parts stores. I have Advanced Auto Parts. We do properties for Rochester Housing Authority. We have 4 or 5 of those in Rochester. We also do for the Postal Service, United Postal Service in Gonick and in Rochester. I also service the Lee Urgent Care, Lee Dollar General, Lee Walgreens, Lee Aroma Joe's, and then there's also condo associations we do work for in Rochester.
Chances are he's plowed the driveway you parked.
We do. Approximately probably 45 in the Rochester area.
How many do you have to serve?
So what happens is when we start out, I'm the main person for the company when it comes to going out to start with. I go around and start running all of the properties. As soon as it starts snowing heavier or more help is needed, we'll call in our subcontractors. You know, with the snowing, there's no way we could one person could take care of all those properties. So as it starts snowing heavier, I condense my route down to a couple of gas stations, the Irving on Columbus Avenue, the Advanced Auto Parts on Columbus Avenue, the 2 Rochester Housing Authority properties off of Brock Street, the Gonick Post Office, the Gonick Circle K or Irving, and Bramber 2 Condo Association on Old Dover Road.
All right, so now we're into April 4th, correct?
Yes.
And have you been plowing all day?
I'd been plowing all night of April 3rd into April 4th in the morning. During the afternoon, snow slowed down a little bit, so we got to do some cleaning up and maybe applying some salt. And then April 4th in the evening, it started coming down pretty well, which that evening was the first time I've ever experienced thunder snow. I don't know if you guys know what that is, but it was coming down at a very heavy clip.
Weathermen get excited about thunder snow.
Sleep?
No, sir.
At some point in time, did things slow down? Did you get to start thinking maybe it's time to go home?
So later on in the day, on April 4th, it definitely started to slow down. I got a call from my boss, I'd say around 9 o'clock. He asked me if I had any salt left on my truck. I said I did. He said, well, if you can go and put a heavy application down on Hannaford on Milton Road, after that you can go, take a break. We're going to be meeting back at Home Depot at 2 a.m. to start running a salt route and coordinating what we're going to do for cleanups for the day.
Okay.
Salt route, not assault.
Getting ready to wrap it up for a while?
That's correct.
What was your plan? How are you going to go about finishing your evening?
I had brought my daughter to work. I did forget about that. I brought my daughter to work the day previous, earlier that day. I don't want her driving in the snow. There's no reason to. I'm out and about in a 4-wheel drive pickup truck. No reason for her to be driving. So she was getting out of work at 10 o'clock. So I was going to Shortyville Plaza over in East Rochester to pick her up and then head home.
Okay. And where does she work?
She works at Rochester House of Pizza.
So in fact, did you pick her up that evening?
I did.
And was it at around 10 o'clock?
It was around 10 o'clock.
And what did you guys do after you picked her up?
Well, she got in the truck. We said, how's it going? Good. We started heading down Eastern Avenue. We turned on Summer Street. And then I came up to the house.
Okay. Jason, at this time we're going to play a video. And with the court's permission, if he could get closer to the television, he has an eyesight problem.
Sure.
Thank you, Your Honor.
He has an eyesight problem, but he drives plows. He has to be that. Hang on. He has to be that close. You've got mail. Yeah, nobody can see through you.
Okay, we're going to start this. I'm going to ask you questions as we move along. You recognize that area?
I do. This is my house right here. This is my front porch, my front steps. That's the utility pole that we saw when we were out there.
Okay. And the utility pole, that's become kind of a focal point. Where is that actually located?
So that utility pole is approximately even with the post on my steps right there. Somewhere around that area. This is a landscaping timber with approximately 4 to 6 feet of grass that's on my property. The landscaping timber runs along the property that runs 43 Summer.
So how far in toward your house is that pole?
In reference to 43 or towards my house?
Well, I mean in reference to the driveway.
It's approximately, I'd say, 6 feet to where the driveway starts. Actually, to the pavement, it's probably about 10 feet. There's a small grassy area on that property as well.
All right. Okay.
Do you want me to play with
Who's that guy?
That's me. I'm pulling up. Before I start plowing any property, I assess the property to see where the old snow bankings are, if anybody's been there to plow it. Even though it's my house, I do have my neighbor at 39, he helps me manage the snow. I noticed that the banking is still there from the plow, so I'm going to back up. I'm going to take most of that snow and plow it into the area of the fence at 39 Summer Street. We're in agreement that because I don't have a lot of place to put snow, I can put the banking there.
All right, so when you're banking snow away from your property, it's going toward 39.
39, that's correct.
Does it ever go toward the home of Kyle Bauer?
At this point, I want to take most of my banking. As you see, I'm going to come in and grab it again and bring it over and put it on the lawn of 39. Because there's no place to put snow over here. As this continues, you'll see when I turn the truck around, I'm trying to pick up the small amount of snow that's right here on the sidewalk, and you'll get a better view from the other camera. The sidewalk is clear by the city, and the snow spills out the side of the plow. I want to clean that up so I have a clean sidewalk there. Okay. And that's when I bring it to right here, a small bank, just what's spilled out right there.
Okay.
But I want the majority of the snow to go that way because he also coordinates with me. We take most of the banking from in front of his house and we bring it behind his house to the park.
You're talking about
39, number 39, that's correct.
All right, let's watch this for a second. You really see okay?
As you see him slowly trying to collect the snow with the plow
No
feed.
objection
That way
here.
I don't make a mess of what the city's done, but I'm trying to grab all the snow.
There's no pending question.
If I leave a banking there, when it melts and refreezes, it becomes icy, or it's water we have to get through to get in our house.
Hey, let me ask you a question.
Yes.
Did anybody ever ask you, did Kyle ever ask you to plow his driveway or plow out in front of his house or anything?
No, sir.
Did anybody from that property ever ask you?
No, sir. Hold on that note, there may have been a conversation with a lady that lived over there another time about they had plowed some snow up on here, and my mother had a Japanese maple there, and I asked them, be careful with that, please don't plow the snow right there, they can use the rest of it, but snow did like, but I asked them not to bother that tree. Okay. And I believe she'd asked me if I could plow their driveway every storm, and I said I work for a commercial company, I can't do residential. However, I mean, if you asked, I would probably open at the end of the driveway for you, but I can't make it an attack.
But I can do my own driveway.
No, I see, we can't hear anything, but cars are going by the road?
Yes.
So what does he do? Blame it on his bad eyesight? I thought he was still coming at me.
Now you see I've turned around, I've had my plow feed, and I'm coming to grab whatever's spilled out of the side of the plow on the sidewalk and make a small banking right there at the telephone pole.
And that's just to clean things up?
Yeah, that's correct. That's what's spilled over on the street side of the plow, and then I'll come in and grab what's spilled over on the house side.
Can we stop it for a second? Just some mechanics with regard to your rig. What year is it? What model is it? What's it equipped with?
So it is not my personal vehicle, so I have to try and jog my memory. I believe it's 2019 or 2021 Ford F550. It's a turbo diesel. It has a 9.5-foot Fisher stainless steel V-plow on it. It has a Boss spreader. That's for the salt.
There's a Boss plow
It's
too.
got the flashing lights. I don't know what else.
Yeah, I mean, we're going to get to a point. I want to ask you, it's a four-wheel drive vehicle, you mentioned that earlier.
It is, yes. It's so it's a commercial vehicle, so it doesn't have the convenient push button you'd have like in a regular vehicle that you would drive, say anybody else. Because of the amount of weight the vehicle has to it, I believe that's why it has the manual locking hub on it.
Okay.
So you have to lock the hub, then you have to shift the transfer case.
Okay, let's continue.
Again, here I'm trying to clean up this little over. That's the telephone pole. Again, I'm not breaching the telephone pole with the plow. Again, just making on the fast trying to clean up what's still out.
Right.
There's a telephone pole and I'm breaching the plow.
Pole's not moving.
Now I'm coming in closer to the landscaping, try and get what's on the sidewalk, keep it clean. Again, I haven't been past the telephone pole.
You're going to hit the telephone pole at this point. If you're on the sidewalk.
At any point, did you distribute any of that snow on Violet driveway problem?
No, sir. Here I am, opening the door.
Okay, if we can stop right there. You're opening the door. What's the reason we can stop right there?
The reason is I'm going out to engage the hubs so I can put it in four-wheel drive. As I mentioned earlier, my boss called and asked me to go and put an application in for it, so I had no salt in the vehicle. Typically, we keep our salt full so that you use the weight of the vehicle to push the snow and you're not being hard on the equipment. The weight of the vehicle will do most of the work for you, as opposed to if you have like a half-ton truck or three-quarter-ton truck, you really need to put some effort into moving this. But a vehicle that size with all the weight in the back, it effortlessly pushes this. So I'm getting ready to back drag my driveway. Without any weight in the back, the wheels are just going to spin there. So when I put in four-wheel drive, I'm able to move that weight back, the snow backwards, without having the weight in the back.
Okay, so it was your intention then to lock the hubs, right?
That's correct.
And then you were going to continue on with some plowing.
That's correct.
And what plowing was it your intent to continue doing?
At this point, once I had the hubs locked, my intent was to go into my driveway, approximately a vehicle length or more, and back drag it out, and then bank it up over onto 39, the grass at 39. Again, pull forward onto the garage, back drag that back out to the sidewalk, push it to 39, and then do that also by the fence. Again, a small back drag, and then the rest of the back drag, and bank it to 39.
Right. Then I assume then call it a night.
Yes, then go in and go to sleep fine.
Okay, and before we start it up again, we see an individual in the driveway. Did you notice the individual at that point in time when you were getting out of the truck?
When I was getting out of the truck, I did not notice anything.
I think he said he did
Tell the
in his
jury,
police statements.
why don't we roll it? Why don't you tell the jury when you first noticed this individual?
From this video, I'm not exactly sure when, but I obviously kneeled down to walk. I don't pause it for a moment.
Okay. You know.
So I don't believe I've seen him at this point because I wouldn't have kneeled down to my hub to lock the hub if I would have seen an individual approaching, especially after the interaction in October, November. So I'm going to have to make an assumption. I don't know for sure, but at this point I don't believe I've noticed him because I would have kept my eyes on him.
How did it come to your attention that somebody was approaching you?
When I stood up, I noticed there was a gentleman approaching me.
Were you up right there?
No, it looks to me that I'm still bent down locking the hub.
Okay, how do we continue?
I'm standing up now.
Okay, hold it. And that would have been the initial confrontation?
Yeah, it looks like I did bend back down. Again, trying to keep up with how it's playing.
Okay.
But he has not approached me yet. He's still working towards me. Okay, now I've stood back up.
Okay. Were you surprised to see him?
I was very surprised.
Had you done anything to cause him any agitation prior to that confrontation?
No, sir. I had not had any interaction with that evening at all.
When he came right up to you, can you tell the jury if he said anything to you?
He said, if you put any stone in front of my house, I'll fucking kill you and your family.
Did that make any sense to you at all?
No, it did not. I had not moved any stone in front of his house.
Now, we've been talking, and we've seen this video a few times, and we're trying to describe just how close he was. We're going to have other videos, but can you describe to the jury how close he was to you?
When he made his initial approach to me, he had finally a resting spot with his nose up against my face.
I mean, I'm going to walk up to you, and you tell me when to stop. Okay? Got it?
Absolutely.
Yeah, this will make an awkward picture.
Which side did he approach you?
He approached me on this side.
Still closer?
Closer.
Can't get it. It's too big. How about that? There you go.
There it
He
is.
actually touched you.
Yes, sir.
Touched you with his face?
Yes.
How'd that make you feel, Jay?
Uncomfortable?
Feel good?
Absolutely.
Do you have any idea what this guy was going to do?
I did not.
So he touches you with his body right on your face, and he says he's going to fucking kill you?
That's correct. In my family.
Did this give you a little flashback of October and November?
It,
Again, while this was going on, was your daughter with you?
She was.
And where was she?
She was in the passenger seat.
She was staying in the truck, from what you know?
I believe so, yes.
So this guy's up against you, literally, flesh on flesh.
Yes.
And is he calmly saying things, or what's his tone of voice?
No, he's extremely agitated. He's yelling at me. He repeated himself again. If you put snow in front of my yard, I'll fucking kill you and your family.
Again, did that make any sense at all?
It didn't. I was frozen. I didn't know what to think. I was confused by the whole thing.
Now, there's been testimony, of course we're going to get to some points here in your testimony, that you were carrying a firearm.
That is correct.
And is that typical of you in certain situations, or what's the deal?
It is behind Home Depot where we park the vehicles and we grab our salt. I had an altercation earlier that year where a gentleman came out of nowhere, approached me as I was getting in the vehicle. He brandished a machete, and I was able to move away from him. We did call the police, and I believe they came and got him. There was no further interactions. But at that point, I decided that my safety was not worth putting in jeopardy.
Did you say that's not a knife?
Right, so when you were doing night plowing jobs and going behind Home Depot, it was typical of you to carry a firearm?
That's correct.
All right, and this night was no different?
That's correct.
Okay, why don't we run the film?
Back of Home Depot's never safe.
Okay,
See here,
hold it. I'll ask a question.
Whatever, I can rewind this a little bit.
Go back a little. What's going on here?
So now he's made a couple of threats about the snow to me. Then he starts on, "You don't believe me?"
Okay, what do you mean by that? What does he say?
The first two times, or I believe he said, "If you put snow in front of my house, I'll kill you and your family." And then he continues with, "You don't believe me? I'll fucking kill you and your family."
That's what he said?
Yes.
Why don't we move? How many times does he approach you like that? Hold on.
It was, I believe, 3 or 4.
Is he saying the same stuff over and over?
He is.
How's that making you feel?
I'm still frozen. I wasn't sure I didn't feel comfortable. I felt like he was enraged. I felt like he was going to harm me and my family. But this time, I was hoping that hopefully he would just do it.
Why don't we go? Again, hold it. Is that another interaction?
That was another interaction where he came right up to my face, nose to face, and threatened to kill me and my family.
Did that have anything to do with snow at the time, or was he just threatening?
Not after the first time or two. He came just, "You don't believe me? I'll kill you and your family." The snow was no longer a factor. Now it was just, he was angry. He wanted to hurt me and my family.
Where we go? Okay, he's backing off here.
He is.
And he stopped.
He did.
Now what happened?
Now he's pointing at me.
What's he saying?
He's saying, "I'm going to kill you and your family."
Stop.
You don't fucking believe me?
Okay. Now what's going on?
He's approaching me again, telling me that he's going to kill me and my family.
You believe in him?
I am now.
All right, why don't we run it? Okay, is that when you approach him? Stop.
Yeah, I think we should probably go back, yeah.
Yeah, why don't we go back? Start there.
This is the best thing.
So now he's approaching me again. Now I've decided the threat is real. Instead of going home, he's now approaching me again. I drew my firearm and I fired at him.
All right. Did you even know? Let's get straight with this. Did you even aim or anything like that?
To the best of my ability, I aimed at the object coming at me. For the person I choose, the object person coming at me.
All right. And what do you see after you fire that first shot?
I see him go down.
We should start it up. And then what? Hold it.
Then I see there was a pause, kind of surprised by the whole thing that happened, I kind of blanked out when I fired the first shot. Then it was like a flash of TV, the TV goes up, comes back on. I saw him getting up, heading towards my front steps, and then I fired again.
Now, there's been some question as to how many shots you fired and so forth. And we played this video, we played videos in slow motion and everything else.
Yes.
Would you agree things happened fairly quickly?
It happened extremely quickly.
Can you tell the jury if you even remember pulling the trigger 5 more times?
I don't remember pulling the trigger the first time, and I don't remember hearing a gunshot. Any of them.
But I mean, obviously, you know you used the firearm.
Yes.
How did you come to the conclusion that 5 shots or 6 shots were fired?
I know that there was 1 in the chamber, 5 in the magazine, and when I was done, the slide was jacked, which would indicate that the firearm was empty.
Okay. And that tipped you off that you had emptied it?
That is correct.
Why don't we play it through a little bit here? As you're going back and still moving?
Yeah, I saw him crawling that way. I heard a female coming from over here. I noticed they did not go to my steps. So at this time, I pay attention to what they're doing. They see another female coming. I go back to the truck to check on my daughter.
So you check on your daughter, and then what do you do?
Check on my daughter. I'm trying to process what's all just happened. I get in the truck. Talk to her, and I said, I'm sorry. You had to see that. She said, no, you're just protecting me. I go to put the truck in drive mode in the driveway. She says to me, what are you doing? And I made a poor joke. Should we run? As I was driving in the driveway. It was an ill-placed joke, but at the time I was kind of in shock, and I guess I was using something to lighten the situation. But
why don't we stop it, and why don't you resume the witness?
Counsel, just so the record's clear, I know that all 3 of these videos are all contained on exhibit number 2, I believe.
It's 2 states, 2 that we're utilizing.
And this is the video shot from 43 Summer Street.
It'll indicate 43 Summer.
I just want to make that clear for the record. That's the tricky part with all 3 videos.
Yeah, it's on 1 exhibit. When you get back there, it'll be 1 flash drive.
Thank you.
And then there'll be 3 of them. Thank you, Jim. So you get back into your driveway, and what do you do there?
Get back in my driveway. Again, when I got back in the truck, I ejected the magazine from the firearm, put them both on my dashboard.
And why did you do that?
What's that?
Why did you do that?
Because I knew that the police were coming. I wanted to make sure the firearm was safe. My daughter's in the vehicle. The police are coming. I don't want to have the firearm on me in case they get some kind of, mixed signal as to what's going on and happen to fire upon me. So I wanted to make sure the firearm was rendered safe at that time. I also had another magazine on me, which I put in the top pocket of my backpack.
All right, so you unloaded. You made the firearm safe. We heard it's a Glock 9mm semi-automatic pistol, correct?
It is a Glock 43 subcompact.
Okay, that's why.
And by subcompact.
It's a small grip.
Absolutely, yes.
And you popped the magazine from it, right?
I ejected the magazine, that's correct.
Separated the magazine from the frame itself.
That is correct.
And then you placed them on the dash.
I did.
And then you had an additional magazine, and where was that located?
That was located in my pocket.
So you had more ammunition, more live ammunition on you.
That is correct.
And you took that, and where'd you put it?
I put it in the top pocket of my backpack. That way it was not resting with the gun. I didn't think it'd be a wise idea to put more live ammunition next to the gun, seeing as I was going to be exiting the vehicle. My daughter was left in there, and the police were coming.
It holds 6
okay,
plus
so
1.
everything was made safe, and did you wait?
Not 5 plus 1.
I did.
Prior to the police coming, did you make any attempts to contact emergency personnel?
So I was in the process of dialing 911 when I saw in my rearview mirror, I saw blue lights coming. So at that point, I discontinued the call. I don't believe I even hit send on it, but I'm not sure.
Well, we heard your daughter testify the same thing. Did you actually have the phone out?
Oh, I had the phone in my hand. That's correct.
All right. Now the police come, and what do you do?
As soon as I see that the officers have exited their vehicles and they're behind my vehicle, I step out with my hands up and I start walking to the back of the truck. When I get to approximately the back of the truck where the Salter is located, I have two officers, a male and a female. Both of them are directing me in two different ways. One is saying, get down on the ground. The other one is saying, walk towards me.
Okay, so at that point, a little bit confused?
I was a little confused, but again, they're both pointing a firearm at me, so I said, I can only listen to one of you. So whichever one of you would like to direct me, I will listen to. The female then stopped talking, and the male officer directed me to walk towards him with my hands above my head.
And did you do everything they asked you to do?
I did. Did you make any statements to them in the driveway,
before you even got officially over to the Rochester PD? What was going on?
I don't believe I did make any statement, or didn't say anything to them in the driveway. When I got into the police cruiser, I did apologize to whoever was sitting in the front seat. I don't know that it was an officer. I did apologize for having to come out that night and for the incident that transpired.
And again, we're talking now somewhere around 10:20ish in the evening when all this stuff starts breaking right in front of your house when you're actually picked up, placed in the cruiser.
That's correct.
And again, just to reiterate, any sleep between 8 a.m. in the morning the previous day and 10:20?
No, sir. Like I said, I clocked in at about around 10 p.m. and I didn't take any breaks or anything. I was clocked in from 10 to 10, 24 hours straight.
Now the jury saw a film clip that we introduced, the video, that would have shown you being processed or actually transported to the Rochester Police Department.
That is correct.
You remember that ride?
Yes, I do.
How were you feeling at that point?
Well, I was feeling exhausted. By that time, when I went on my way home, all I was hoping for was my bed. When you work that long, you start getting to the point where all you're thinking about is getting to a point to lay down. So I was exhausted, and I was definitely a little frustrated that I wasn't going to lay down.
Your Honor, can we approach this?
Yes, you may.
So the key part of the testimony that we heard here from the defendant is that the first shot, that he said that I don't remember hearing it. I don't remember pulling the trigger. But he shot once, and then it looked like he was getting up, headed towards my house. That's where he's got the in defense of others portion of his claim. I'm not sure if the jury's going to buy that one.
Take a break. We do have to take a lunch break at some point. We're going to stop now, and we're going to take our hour lunch break. And so we'll be back here at 1 o'clock. All right? Jury can be excused. Please rise.
So they're going to head to lunch.
Handed out my jury instructions. You could use the lunch hour at different times to take a look at those. And if you have some points on a raise, you can get back some lunch and get back a couple minutes before 1. Do that, that would be great. I missed that. I'm sorry. Jury instructions. Right. If you have any...
Review the jury instructions, what it's saying.
Jury dialogue, God.
She told me not to do anything.
That's true. All right. Thank you, Bob. We'll see you back here.
Sorry about that. I don't know if I don't know if the defense has a lot more to question him on. I think they want to keep it pretty simple. But We might be, after lunch, going to cross-examination. After a short delay, I think we're going to have probably... He has to account for what he told the police. He has to account for the story he told the officers in that interrogation room, why it was different. I think we've got a good indication of what he's going to say. He's already said how tired he was, that he doesn't remember the shooting, how many shots he fired. He's told the key parts that were important for his story, specifically that he felt threatened initially, that he believed the threats, and until that point he just wanted it to go away, and then he felt threatened. That's when he took action. Those are the right words to say in a self-defense case. Whether or not the jury believes it, that's another matter. And then after he fired the first shot, he says he saw him getting up, heading towards his house, like my own house. He was headed toward where my family was. That sort of invokes the side of in defense of others, which is the right thing to say in a self-defense case. Once again, the jury probably won't believe that because they have video that shows him looks like he's crawling straight towards the camera, which is on his own house. So, but he's said the right words so far. Has been confident. Now he has to explain his lies. The lies are going to, how he does that, how believable he is. That's very, very important right now for his defense. And the story he told, the snow plowing, having worked for a landscape and snowplow company, I can tell you that that checks out as far as the weight, the hubs, the hours, all that. It seems to make sense. His knowledge about snow plowing seems quite thorough. How he describes what he was doing seems quite thorough. I think the jury can safely assume that he was not trying to push snow on the neighbor's yard. He was not trying to instigate anything in that front, but that's not what this case is about. Where he raised emotion, thinking about his daughter, I think that's out of regret because he sees what he did and what that can do to his life. So interesting approach to have to stand 1 foot from the TV to be able to see what happens. It does give him the benefit of being able to point right to the TV and say, "Look right here. See the pole? I didn't pull past that. See that? That was the benefit." I don't believe for a second that his eyesight is that bad. That just now we find out in court that he watches TV from basically sitting on the TV. Not buying that. The next part's going to be crucial though. All right, we have a portal set up. We're going to take a lunch. Know this, after lunch, as soon as cross-examination ends, we're probably going to break and go. Well, it depends. If it's spicy, we're going to stick with it for closings, and then we'll break during verdict watch and pick up the North Dakota case, Nicole Rice case. So those are coming up soon. Dangerous to drive a snowplow with bad eyesight? Yes. It's first of all, snow makes it impossible to see anything. It's very hard to judge distances in snow. Because all the objects that you would reference are obscured in the same color. Light plays tricks on your eyes. Snowplow drivers hit things all the time, and these are guys with great vision and with years of practice. They hit cars, they hit fire hydrants, they hit curbs, they hit manhole covers, they hit potholes. They hit stuff all the time, and having terrible eyesight and snowplowing is a bad mix. Maybe his eyesight has declined in jail since this event. Yes, and it's also possible that he doesn't have glasses and he needs them. But, usually if you need glasses, you'll get them in jail as well. Let's see. Holy cow, Melanie. CIA headquarters in Langley? What is going on? See if I can find something here. A new station alert has arrived. New station alert has arrived. That's different. where are you seeing this? SWAT teams descend on CIA headquarters after man fires gunshots. That's the Mirror Online. The UK is carrying that story. Daily Nowhere, massive police presence near CIA headquarters after a man reportedly fired several shots into the air with an unknown weapon. I'm guessing it was a gun. I'm seeing a lot of people milling around, but not a lot of SWAT teams. So we do have a portal set up for this afternoon's live stream. Please join us for that one. We also have, we'll do another portal after that as well. Let's see. All right, we're gonna take a break, a lunch break. I'm sorry, I need to stop reading texts because it distracts me. There we go. It's portal time. We're portal over to part 2 of this trial. Then after that, we're going to do part 2 of the North Dakota trial, which will probably take us into about 6:30ish tonight. So hopefully you don't have anything on the schedule. You can stick with us for the whole thing. That next trial is going to be a juicy one as well. This one might be spicy after lunch, as defense eventually is going to cross-examine the defendant. And they're going to ask him some questions about some lies he told, and I'm not sure if they're going to buy his answers. So we'll see if they're able to impeach him. If they are, it does not look good for this defendant. It's already an uphill battle. So time to go home. Please hug the people you love. Smile at someone. Make their day just a little bit better. Please stay safe till we go live in about 45 minutes. We'll be live just before 1 o'clock. That's where we return for part 2. You guys have yourself a wonderful lunch. I'm going to go check in with Mrs. R.A. I think I have an Amazon package. Maybe. So we'll see if that came as well. I'm also going to go look for bike seats. See if there's some padded bike seats available. I tell you, it hurts. The pain is real. You guys have a good day. We'll see you in a bit. Bye.